Yes, so I see myself on the live screen. Yeah, maybe the screen sharing can also be added. Yes, Jazakallah. Okay, Assalamu alaikum. Assalamu alaikum warahmatullahi wabarakatuh to all the participants from Masjid An-Noor, Florida. This is Nabil Matra. I'm the MD at barkatfinancial.com. Today I'm going to talk a little bit about will and trust, basically on your estate planning in terms of Florida state. So to begin, have a quick introduction. I would like to thank the opportunity given to me by the board at Masjid An-Noor for inviting me to make this presentation on a very, very important topic, because just like clockwork, almost every month we see a request for funds, requesting for fund in terms of medical bills, or whether it comes to expenses, final expenses for burial, almost on a monthly basis. I'm sure you must be seeing it as well. So today's session is how we can navigate the rules and system within the state of Florida, and protect our family in advance, so that we don't run into financial situations where we are requesting for money for medical bills or final expenses. So with that, I will get started. Just a brief introduction about myself. Once again, my name is Nabil Matra. I'm the owner of Barkat Financial Services. I'm based out of Mechanicsville, that's near Richmond in Virginia. I am a licensed professional, and I've been running this business for close to 4 years now. So today's topic is session on Florida estate will and trust planning. So as you noticed in the topic is state specific. It is focusing on Florida estate. Why we specifically said Florida? Because every state has its own probate court, right? Every state has its own probate jurisdiction, which decides how to deal with the estate planning in your specific state. And that is why we are focusing on Florida estate alone at the moment. Because if you were to go outside Florida, you would have to prepare a separate will and trust. So every will and trust rule is specific to the state of where your primary home is located at. Now, one thing to note is will and trust is a strategy, right? Will and trust is not like a set of papers that just needs to be done, and then you are, you're doing it like a documentation purpose. It's That should not be our mindset. So, as part of Barkat Financial, I'm also a business coach and a financial coach. So we coach people on how to protect their asset. So if you look at your financial house, consider your wealth and assets as a financial house. The foundation should be your protection. And what all comes under protection? This is the key part, because without the foundation, the house will not stand, correct? So what all comes under your protection here? So for that, I'm sorry about that. Yeah. So what all comes under that is life health insurance, cash and short-term liquidity, initial risk management review, estate planning and design, disability income replacement, and long-term care plan. So basically, we want to make sure that we are holding on to our hard-earned money. We don't want, if you earn say around 100,000 to 150,000, which is what most households are able to do, alhamdulillah, you are considered among the top 10%, right? So most of our people are among the top 10% of income earners in the USA. But at the same time, we are also falling under the top 6% of taxpayers. So what is happening is at one end we are earning good money, but at the other end we are failing to hold on to our hard-earned money. We are losing it through taxes, and other means and other fees, right? So if you see, the estate planning is one of the key foundation stones of your foundation of your financial house. So once you have your protection of the foundation built in place, then you can do whatever you want. You can go into your 401ks or your Roth IRAs, or you might have any other some investment or your rental properties. All that is good. But what we see mostly within our community, especially who are first generation immigrants, we are not very much savvy with the rules and regulations here in the country, right? So what happens is, say for example, if somebody gets a bonus or extra cash, what they do, if it is men, they typically go and buy a new car. Or if it is, on the ladies side, they'd like to upgrade their patio or upgrade their kitchen. I don't mean to point fingers or blame anyone, but I'm just thinking, the mindset needs a slight shift, because we need to start building from the foundation up. We shouldn't go where we are starting from the top and then coming down. That is not how the house is built, right? The house has to be built from the foundation. So when I am trying to explain here is, see will and trust as a strategy of your financial foundation. Now, this foundation that we showed in this picture, we are also referring it to as circle of safety. Why it is a circle of safety? Because anyone and everyone needs a circle of safety, right? Within the United States, it doesn't matter if you're an engineer, or whether you're a doctor, or whether you're a nurse, or whether you are a scientist, or whether you're running a gas station. It doesn't matter what kind of job or role that you have. Everybody needs this. So what is the circle of safety? The circle of safety has 6 components when it comes to protecting your assets. 5 things to be taken care of while you're alive, and the 6th thing is to be taken care of so that there is smooth transition of legacy. So what are the 5 things that all of us are looking after? We are all planning for our kids' college planning. We want to save for our kids' college. We want to save for our kids' marriage. Retirement is a key factor, because a lot of us don't account for inflation and tax. If you ask what age you want to retire or how much you want to save for retirement, that is not, it's a guesstimate at best, because especially for people in the 50s and 60s, if you look, your working years are going now less than the number of years ideally you would spend in retirement, because with the advancement of medical technology, the average lifespan has gone to 80 to 85. When 401k first came in, the average lifespan was 65 years, right? Now it's gone up to 80, 85 years. How are we going to fund for this extra 20 years? Long-term care and medical, presentation here. 2 out of 3 bankruptcies are because of medical bills. All right. And if you look at the travel or life called bucket list items, that is, some people, they want that extra home, or they want that fancy car. So that is what comes under your bucket list item. So 5 things to be taken care of. 5 things to be taken care of while we are alive. And the 6th thing is legacy planning, which we are going to deep dive into now. Because we work hard, we put in a lot of effort, we want all the transition to happen very smoothly, right? We don't want any friction or any confusion when the assets are being transitioned from one generation to the other. Okay. So now I hope this was clear. First, we are talking about how will and trust is part of your big strategy of your financial house. Now we are going to deep dive into the concepts of will and trust. So what all are there when it comes to will and trust? First, this is a question that I get asked very often. What is a will and what is a trust? And it's important to understand the difference between the two, because Some people, they have only partial knowledge. They create either only a trust and they create only a will, which kind of defeats the purpose, because your will and trust are actually complementary to each other. So it's important to understand how it works. So let's start with a will. What is a will? A will is actually only your wish list. Okay, it is your desire, it is your plan of how you want to distribute your assets. Say you want the house to go to the wife, the cars to go to the children, the bank account to go to your grandkids. How you want to plan to distribute the assets, that is plan is what is going to be defined in the will. Now what is a trust? If you look at the will, it is just your plan, right? It is just a blueprint. Every plan needs to be executed, correct? So how do we execute the blueprint? That is where the trust comes in. So consider trust as a separate entity, something similar to like, for example sake I'm giving, you might be aware of what an LLC is. So it's a separate legal entity which consists of a group of people called trustees, right? The trustees you appoint. So you know these people are trustworthy and they will execute what the plan defined in the will. So once again, the will is just your plan. The trust is the executive body, which will execute what you have instructed as per the will. I hope that difference is clear between the will and trust. So that is why it is important to have a combination of will and trust. And there are actually additional documents also that is needed, which is what we'll be covering today. That is why today's topic is estate planning. So when we say estate planning means, it means that all the set of documents that you need to have in hand when the time comes, if somebody passes away. Again, what is estate planning? When we say estate, typically if you're from the Indian subcontinent, people have the wrong misunderstanding that estate means, millions of dollars and, acres of lands and things like that. No, but not in the USA. In the USA, estate means anything you leave behind is considered as estate, right? Like suppose a person passes away and he has only $1,000 in his bank, nothing else. Even that $1,000 is referred to as estate in the USA. That is why we refer to the whole process as estate planning. So we are not just going to create will and trust, we are going to create other supporting documents like financial power of attorney, health power of attorney, HIPAA identification, all those kind of additional supporting documents, all we are going to talk about today. Now, just a quick disclaimer, I'm not an attorney myself. I'm the owner of barkatfinancial.com. So we have a tie-up with a company called NetLaw, which is a software company that is built by a group of attorneys. They're an award-winning company. It's netlaw.com. Now, here are a few questions to get you thinking. Are you okay with the state of Florida deciding what happens to you and your possessions? Should something happen to you, have you specified who will take care of your children? If something happens to you, do you know who will make healthcare and life decisions for you? Have you completed a HIPAA form? So select members of your family will have your medical info access. Now, this is a common misunderstanding, especially among the first generation immigrants, because we come from a different country. We have been following a different medical system all throughout. Back in our respective countries, whether it's Bangladesh, Pakistan, India, wherever you might be from, people tend to have their relatives in the hospital, right? And the relatives tend to have access to all the medical records and are able to call the shots when it comes to what kind of treatments are needed or not. Here, that is not the case. In some states, even for your spouse, you have to specifically call out that your spouse is responsible for making medical decisions on your behalf. Now, if you're incapacitated, have you identified who will handle your financial and legal affairs? So when we say estate planning, it's not just about a person passing away, it's not just about death. There are some things that need to be taken care of even when the person is alive. Like, for example, a person might be incapacitated. He might have a stroke where he or she is not able to sign the check, or they might fall into a coma, where again they are not able to pay the mortgage or the utility bills. So for all those things, it's very important to have a financial power of attorney defined. Have you specified how your estate will be distributed? That is where it comes through, the importance of will is there. Do you want your family going through the probate process at time of one's death? So this is a very key question. I request all of you to think about it. Do you want your family going through probate process at the time of one's death? As it is going to be a very stressful, very emotional situation. On top of that, do we want our family members, walking up and down the court, booking appointment time with the lawyers and probate court, spending a lot of money and time? So the key process that we're going to discuss today is about how to avoid the probate process. If you can do that one small and simple thing, it's very simple. Whatever I'm going to educate here is very, very simple. If you can just do the small process of avoiding the probate process, you avoided more than 80% of the headache. Okay, so please focus on that. Our whole explanation here is about how to avoid the probate process. Now let's take the example of a young couple. Okay, they have two children. Now they have a will only, and this is again a scenario I see very commonly. People, they have a partial understanding of how the estate process works, and they prepare only the will. Alhamdulillah, something is better than nothing, because if you don't have a will and trust, that's much more worse than not having at least a will. So if you have a will, that's well and good, but ideally we need to have the complete estate planning. So here what happens is, because they don't have a trust, again, why did we say there should be a trust? To execute the will, right? So the probate court, every state in the USA has a probate court, right? And it is there for a good purpose, because more than 68% of the US population does not have a will and trust. 68%, that's more than half of the people. So if they pass away, there should be some institution or some sort of mechanism to which their estates have to be distributed. So if a person does not have a will, the probate court will create the will for that person, and then if they don't have a trust, the probate court will execute what they created in their own will. Now, while the intentions are good, the other downside is, if you have minor children under the age of 18 years, they are going to go to the foster care. So until this whole probate case gets resolved, which is typically 3 to 6 months, and in some states where there are huge backlog, it can be up to more than a year also. These young children are going to end up in the foster care. No uncle, no auntie, no relative, no cousin, nobody can come and claim the children until the whole probate case is resolved. So you see, this is a different situation from how it is back in our country. So the kids will be under custody by the foster care until the probate case is resolved. Now, suppose we consider the good condition, where the person, they have the will in place, they have the financial power of attorney in place, they have the health power of attorney in place, they have a living trust. All this is defined. So in this case, you can completely bypass the probate process. So it's very simple if you think about it. Our main goal here is to avoid the probate process. Now I'll just touch upon a few keywords that you'll definitely keep hearing when it comes to estate planning. One is will. Again, what is a will? It is just a blueprint. It is just a plan where you decide who will get your things, who is going to take care of your children, who gets your home, etc. Okay. A simple will alone will not transfer the real estate. This is just showing your intention. Power of attorney, like who can pay your bills if you and this is just, we have seen the scenario, at least in our community, where the father has a stroke and he's not able to sign the checks, and if the kids, they withdraw the money from his bank account, it is considered illegal. It is not legal for the kids to withdraw the money or sign the check on his behalf. But if you have defined in advance that there is a financial power of attorney, then you have representatives who can sign on your behalf. Healthcare surrogate. This is also called healthcare power of attorney. So this document will decide who gets to make medical decisions on your behalf. Maybe the person is in a coma and they need a surgery. Then, but with this document, will define who has the right to make medical decisions on behalf of the person who is in coma. Living will declaration. Why I'm showing all this is these are all the forms that are actually required as part of your estate planning. So um, please don't limit yourself, to think that just will and trust is sufficient. Will and trust alone is good, but when it comes to comprehensive estate planning, you need to have all these documents in place. Living will declaration, also called an advance directive. Like some people, they might have a preference of what treatment to take, what treatments not to take, right? So all that can be done by means of advance directive. Like for example, some people, they don't want to give blood transfusion, especially within our religious constraints, we don't want to donate organs after death. So all those kind of things can be mentioned here in the advance directive. Then there is HIPAA authorization. For those of you who are in the medical field, like doctors or nurses, or even IT people who work in the healthcare domain, know very well about HIPAA, how privacy is a huge thing here in the USA. So you need to specify the HIPAA authorization. Maybe even when you go for your annual checkup, they might give you a HIPAA form asking who all can have access to your medical records, right? So here we need to specify the healthcare power of attorney as to who all can have access to your medical and psychotherapy notes. Living trust. Now, again, when we talked about the difference between will and trust, we said will is your blueprint. It is your plan of how the assets need to be distributed. Trust is the executive body, right? It consists of your trustees who are going to execute what is in your will as per your desire. Now, why do we have the will and trust in place? Again, to avoid probate. It's very simple. Just keep this concept in your mind. Avoid probate. That is the first thing we have to do, right? Avoiding probate. So, a combination of will and living trust will help us make sure that we can avoid probate. Now, here we specifically talk about living trust because for most of our practical purposes, living trust is sufficient. There is a difference. There are two types of trust. There's revocable and irrevocable. As the name suggests, irrevocable means once you write it, you cannot change the trust. It's difficult to modify it, right? Revocable trust means, as the name suggests, you can keep modifying it multiple times. Because, say, for example, down the line, you buy a new rental property or some sort of land investments, you want to add that into your trusts. For that, it should be modifiable, right? That's why we go with a revocable trust. Or maybe there might be a change in family situation. Maybe a child is born or maybe a grandchild is born, and then you decide, I need to rearrange the percentage of distribution of my assets. So for those purposes, we can use a revocable trust. Again, the whole concept is very simple. We are going for estate planning. We are going to create will and trust documents, all to avoid the probate process. If you can please take away that one point, that I need to avoid the probate court process. That's it. I think this session would be a success. That is the just one key takeaway. Okay. So by avoiding the probate process, what are we doing? We are taking care of our children. We don't want the children to go to the foster care. Financials are handled by a trusted person through a power of attorney. Medical decisions are handled by the family, because otherwise what will happen is the hospital or the medical institution is going to take the decisions, which might not be the best option, right? And then legacy transfer. We want all the assets to be transferred in a smooth manner without any interruption. And a couple more keywords I'll just familiarize with you, because you will come across this when you're preparing a will and trust. It is testate and intestate. Very simply put, if I may educate you in a very simple manner, testate is that you have all your documents correctly in place. Intestate means either you don't have the documents at all, or it is, excuse me, either it is not present at all, or it is only partially filled, right? So in the case of a will, if it is testate, it means you have appointed your executor, you have appointed a guardian of your minor children. If it is intestate, again, that is where the probate court comes into the picture. They are going to appoint executors, and they are going to take hold of minor children in the foster care until the whole probate court case is resolved. Same thing goes for healthcare, power of attorney, and financial power of attorney. If you have documents, you're considered testate. If you do not have documents, you're considered intestate. Okay. Now, here are some of the advantages of having a revocable trust. Again, revocable trust means you can keep modifying it, right? A revocable trust will become irrevocable or non-modifiable only when the person passes away. So as long as the person is alive, he can keep modifying the trust. But once he passes away, it becomes irrevocable. Then nobody can make any more changes to the trust. So what are the key advantages? You have flexibility. Flexibility in the sense you can keep adding. It gives you flexibility and control. You can keep adding and removing assets into your trust. Privacy. Now, what you mean by privacy is if you move your assets to a trust, nobody will know how much assets you have. Because otherwise, if a person passes away without will and trust, the probate court, what they're going to do, first they're going to take stock of what all assets he has, and then they're going to publish it, right? So all your assets will be public information. If you want to avoid that, you can create a trust and move your assets into a trust. So at the most, what people can see is the name of the trust. They cannot see what is inside the trust. Okay. Financial security, easy asset management, and immediate access to funds. This is a key point: immediate access to funds. Please make sure that you have beneficiaries, or it's called POD for your bank account, payable on death. Please make sure that you have defined all the beneficiaries and contingent beneficiaries on your bank account, because a lot of these GoFundMe's that we see are not because the cash is not there. Like if the father passes away and you see a GoFundMe coming, some of the cases it's not because the father did not have the money. It's because the money is there in the bank and the family cannot access it immediately for the burial and other final right expenses. Okay, so if you have your will and trust in place, if you have proper beneficiaries and contingent beneficiaries defined, your family can access your bank account. And I hope sisters are listening to this session, because somehow there is a mentality, that my husband will take care of it. But in the USA, we need to have that slight mindset shift. Yes, we trust our spouses. We are sure our spouses are responsible, but you need to know what are your responsibilities and what things you as a wife need to be aware of when the time comes, right? So please be involved. Please be aware of what the bank account accessibility details are, because on a monthly basis, we see one incident or the other within the community across North America, right? And a repeated pattern is, something happens to one spouse, then the wife doesn't know the password of the computer, the phone. Not that I'm telling it should be shared, but at least they should have some navigation option where they know where the finances are and how to access the money. Now, two other important points is there is no asset protection and there is no tax advantage. Please do not misunderstand will and trust as a insurance policy. This is not an insurance policy. So there is no asset protection, which means if you have a car, say the car needs to go to your son and the car ends up in some sort of accident, the will and trust is not going to pay for it. This is not an insurance policy, and there is no tax advantage. Like if somebody inherits the excuse me, house through a will and trust, they still have to pay the property tax. So this is not tax exempt. Okay. So there are some category of items called non-probate property. So far, what has been our mantra so far? What are we trying to take away from the session? Very simple: avoid the probate court. Right. The whole idea of this session is how we can avoid the probate court process when the time comes. Now, there are some things which, if even if you don't mention in the will and trust, the probate court cannot touch. What are those items? So they're called non-probate property. One is life insurance with beneficiary designation. This is important. If you have a life insurance, please make sure the beneficiary is designated. Otherwise, it is still going to the probate court. Retirement accounts with beneficiary designation. This is also another gap we see very often. Please make sure that your 401k, your Roth IRA, all your retirement accounts have a beneficiary designated and contingent beneficiary also designated. Property owned jointly with rights of survivorship. That means if the deed is in the name of the husband and wife, okay, this is again something we see. We typically see the mortgage is in the name of the husband alone, the deed is in the name of the husband alone. If the mortgage can be a loan in the name of the husband, but if the deed is there, it is highly recommended to have the deed in the name of the husband and wife. That way, if something happens to one spouse, the other spouse can automatically take control from there. So that is what is meant by property owned jointly with rights of survivorship. And then finally, property owned by a properly drafted trust. As we just discussed, if you move your assets into a trust, then the probate court cannot touch it. Again, please remember probate versus tax. If something is there in your will and trust, it does not mean that it is tax. It's not an insurance policy, or it is not a tax advantage, right? If probate estate and taxable estate are not necessarily the same. So the way the IRS calculates the estate is not the same as how the probate court calculates the estate. Wherever tax is applicable will have to be paid. If you avoid probate court, it does not necessarily mean that you're avoiding IRS taxes. Okay. So just a quick recap. I'll be winding up in 5 minutes, and then we can open it up for question answers. Again, why is it important? This is a very simple concept. We don't want government to make decisions on our family assets, etc. Very simple. What we are doing is just creating 5 to 6 documents, and we are making sure that there is no headache when the time comes. Over 60% of the Americans do not have a will or estate planning. Over 90% of Americans do not have an updated will or estate planning. So out of 600%, only 40% of the US population has a will and trust. And within that, 90% is not updated. Not updated means if they bought an additional house or rental property, or if there's a new child in the family, or if the marital status has changed. For all these scenarios, the will and trust has to be modified. Without a will, power of attorney, and healthcare documents, you might be putting your family at risk. If you don't plan for it, then the state will plan for your assets and minor children. Okay. So this is a question for you. I hope you understood how simple the process is. At the same time, I'm using this slide, just to prompt you, to encourage you to take action immediately, brothers and sisters. Let's not delay the whole process. It's very simple. You just need to make sure that you're avoiding the probate process. So please take the necessary action. I know the common questions I hear are, it's too expensive, or, I'll do it later, or is this for me? Yes, it is for me. This question especially comes from green card holders and H-1B visa holders and other visa holders. Yes, it is for you, because it does this. estate will and trust is not for people, like having millions of dollars. No, our whole goal here is about avoiding the probate process, right? Now, for example, I'll take example of H1B, people on H1B visa. Just because they're working here, are they exempt from tax? Is IRS exempting them from tax? No. As long as they're working on US soil, they are going to be having to pay tax. Same way, as long as they're working on US soil, the probate court can interfere with their financial asset. If somebody passes away, can take the children, even non-US born children, to foster care. And then, of course, some people, they tell me that they already know. Yes, it's good to have knowledge, but without application, knowledge is not very useful. And then some people say, let me research more. All power to you, but the thing is, we need to take immediate action to avoid interference from probate court. It's a very simple process, and I don't see much point in getting the whole process delayed. So with that, I will just conclude my session, and I'll just open it up for. I have few more announcements. I have special announcements for all of the participants at Masjid An-Noor, but I'll just open it up for questions. Brother Kader or Brother Shanwas, if there are any questions, I can take it up. Okay, I see the questions coming in now. Okay, there is a question from Brother Iqbal. The first one is, what happens to mortgage if husband on mortgage and both husband and wife are on the deed? Yeah. So the mortgage will become the responsibility of the spouse that survives, right? And that is more on, that comes more into insurance and emergency fund planning. I think that could be a different topic. If the board is interested, that could be a different topic for a different day. But at a high level, to answer your question, yes, if something happens to the husband and the mortgage is the name of the husband, then the mortgage becomes of the responsibility of the person who inherits the house, which will be the spouse, because both the husband and wife are on the deed. Second question is, should we put investment property in revocable trust or out of it? Okay, that's a good question. So if you think the investment property you're going to keep for many years, like maybe at least 2 to 5 years, yes, keep it in the revocable trust. But there are some people, who buy and flip properties. You can do that, or you can create a separate trust just for buying and flipping investment properties, because if you're doing it in 3 to 6 months, it doesn't make sense to keep adding and removing it from the trust, right? Or you could have a separate trust just for flipping the properties. But if you are planning to keep the property for long term, then yes, please move it to the trust. Some people, they don't move their house or other properties into the trust because they want to, you might have heard of home equity loans, HELOCs. They want to pull the money out from, they want to use the equity, they want to leverage the equity to buy other business or other investments. So for that reason, they don't put it in the trust also. If there are more questions, please share. Please share via. I think there is a form for submitting the questions. So please utilize the form. I'll be happy to take any questions you have. Okay, so I hope you can see the screen. Please feel free to take a screenshot. It has all the contact details of how you can reach me. And I just wanted to announce that we are giving a special 50% discount for all the attendees from Masjid An-Noor. And thanks to the board at Masjid An-Noor for making this happen. So typically, if you were to go to a lawyer, right, they would charge you 1,000 to 3,000 to get a will and trust and estate planning docs created. But if you come to us, we have a tie-up with this company called NetLaw, where we can give it to you for $600. Plus, we have worked out additional benefits for members of Masjid An-Noor with your board. Um, First thing is we are offering a 50% discount. So instead of $600, you can get the package for just $300. Plus, we are giving it free for the spouse also. So for the price of one, you can do the will and trust for the husband as well as the wife. Okay, we have a question from Brother Shan. It says, what if both the spouse pass away, and how can someone outside their family access the will and trust? Okay, yeah, that's a great question. So the question is, what if both the spouse pass away, and how can someone outside the family access the will and trust? So that is the objective of creating a trust. So in the trust, we are going to identify trustees, right? So what is the role of a trustee? The role of a trustee is to take care of the assets and distribute it. So if there is a husband and a wife, and maybe they have appointed their brother-in-law as a trustee, because that is one of the things you will do when you create the trust. You will assign a trustee. So that trustee can take care of things and distribute the house to the kids. Okay, it will be the responsibility of the trustee to do that. So again, yeah, if both the spouses are not there, that is when the trust comes into effect. The other question is, how can NetLaw help when you move out of state? Okay, that's a great question. Again, this is a special offer for participants at Masjid An-Noor. You can make unlimited modifications. Okay, we are taking off the subscription fee. Typically, there is a monthly subscription fee of $8 per month. We are taking this out again for the members at Masjid An-Noor. What this means is, suppose you create will and trust using this NetLaw software for Florida, where you're staying now in your primary residence, and maybe down the line you shift to, say, maybe Virginia, or if you move to North Carolina, you can come back and use the same software. You don't have to pay anything extra. You can come back and update the software and create a brand new will and trust. Now, for a will and trust to be effective, it has to be notarized in front of two witnesses, right? So when you created your first version in Florida, that would have had to be notarized in front of two witnesses. Now, to invalidate the old one, you come back and you update the software with your, say, North Carolina, whichever new state you're going to, and you print it and you notarize it in front of two witnesses. Now that will become the latest legal version. The old Florida version becomes invalidated. Now, the follow-up question is, if I prepare will and trust in Florida and move out of state, will there be a big change in the execution? Can you please elaborate? See, essentially, the execution is handled by the trust. You define the execution activities in the trust. So whether you're in Florida or whether you're in North Carolina, it's up to you how you want to decide the distribution. You might say the Florida house needs to go to my first kid. The North Carolina house needs to go to my second kid. Again, it's software. It's very, very simple. This is not at all complicated. It's going to be very simple. Okay, yeah. Please use the link. There is a link the board might have shared with you. Please use the link to share questions. Do you make the trust in accordance to the Islamic rules? This is from Brother Bashar al-Bashir. Okay, so I just want to clarify, the topic for today is Florida estate planning. So my focus area is on how things work in your state. Okay, I'm not specializing in Islamic will, and there is a reason for that, because people, they create only a will or a Islamic will, and as I explained to you before, that is not sufficient to get them through the probate court process. Okay, we are in the USA. We are not, unfortunately, this is not a Sharia state where an Islamic will alone will see us through. So I hope my whole goal of today's explanation was to explain how to navigate the Florida estate planning system. That being said, there is a provision for Islamic will. You know what I have my clients do is they talk to their imam or they talk to a Maulana who is a specialist in Islamic will, and they distribute, like 2 units to the son, 1 unit to the child, one fourth to the wife. They do that calculation with their imam and then they bring it to me and we upload it to the software. So you can plug in the Islamic will into this software. Yeah, we have about 10 more minutes. Looking forward to more questions. I'll be happy to answer. Please use the form shared by the board for entering your questions, please. Yeah. So regarding coming back to the discount, to claim a discount, please take a snapshot of this. This will give you how to contact me. And please note this code. The code is MAN50 for Masjid An-Noor, 50% discount. It's MAN50. Please make a note of this code. You may take a snapshot of this whole screen. Okay, another great question that has just come in. It says, I don't know how to access the Netlo website and software. Will you be able to walk me through? 100%. So what we specialize in as an organization is, our firm, we specialize in coaching. Okay, we are into educating you, we are into empowering you. Like, we don't just sell the Netlo and disappear. No, that is not what we do, because we want to empower you and make sure that you complete the process, right? A lot of things are in your control, like how you notarize it, how you get the witnesses. That is all in your control. But that being said, we will be there with you every step of the way to clarify any questions that you might have. Our goal, the reason I'm an independent consultancy, I don't belong to Netlaw, I don't belong to AIG, I don't belong to New York Life, I don't belong to any of these companies. The reason I am independent is so that I can empower you. My goal is to teach you. Like, I will show you how to operate the Netlaw and become a master of it by yourself, right? Tomorrow, if you move from Florida to North Carolina, our goal is that you should be able to update the will and trust by yourself. So yes, we are not just going to set it up for you and and disappear. To say, our goal is to educate you and support you through the whole process to make sure that you complete everything. So if even if someone approaches us, for life and health insurance, or a long-term care planning, because 2 out of 3 bankruptcies in the USA is caused by medical bills. So how do you plan for better for medical bills? And there is a reason for that. This bankruptcy is happening to normal people like you and me. Bankruptcy is not happening to somebody very poor or somebody who cannot afford, housing and food and shelter. No, this is happening to normal people like you and me, because, for example, what happens is, if I were to ask somebody, like, do you have life and health insurance? Of course, setting aside the Islamic religious aspect of it, most people will say, yes, I have it through my company. But if you become critically or chronically ill, right? Like, if you're incapacitated, or if somebody comes into a coma, or God forbid there is cancer or something like that, what happens? Are you employable then? No, then we are not employable, correct? If something happens to us, we are not employable. If we are not employable, then what happens naturally? The companies will try to terminate our job. If we terminate, if we lose our job, then we no longer have our life or health insurance. So it's important that we have our own plan and not to depend on the companies alone to protect us. Okay. So yes, again, we do a consultation based approach. We do, what we do is, our goal is to empower you, right? Because I think almost every month we are seeing this, money being collected for one reason or the other. And I feel to a certain extent, if we had educated ourselves, understood how simple the process is, how simple we can easily do it. It's not very complicated. How simply we can take care of it ourselves, so that we can take care of our families ourselves rather than having to depend outside. So, I think we have about 5 more minutes. Do we have any more? Please use the link shared by the board, and please ask. A lot of great questions coming in. Please put in more questions. I don't see any questions from the sisters. Sisters are also encouraged to ask. Okay, another question that has come in is there anything specific for H1B holders? This is a great question. Please note this will and trust rule is estate planning rule is applicable to anyone in the USA. Right? We had an unfortunate scenario, I think it was 2 years back, where H1B couple, both husband and wife were on H1 and H4. They passed away, and their 2-year-old daughter was in the foster care. So yes, it doesn't matter whether you're a US citizen or not. This is applicable for everyone. There's nothing extra you need to do as H1B. No, there's nothing extra. That the process is going to be the same. I hope you've all taken the snapshot of what is on the screen. Please make use of the code MAN50. This is going to give you a 50% discount, so that we know, you're coming from Masjid An-Noor. That way our team will be able to process it faster. And I'm sure there'll be a survey also coming up after this. So if you want to learn about more topics like college savings, medical bill savings, tax-free retirement income, please let the brothers on the board know, and we can definitely arrange for those topics in the future. Okay. Yeah, and one more key point, and see, the board or myself are not doing this presentation for a profit basis. This is purely community service, right? Because you can imagine the price is being brought down from $600 to $300, which will be, used for the admin and netlaw processing fees. So this is not a profitability discussion that we are here. We are not selling anything here for profit. We are not in no way making money out of this. Just to clarify this is a community service that we are doing. So I do this across the multiple states. We take these kind of sessions to educate the brothers and sisters, so that it's a very simple process. You can take the simple action to protect your family from having to go into GoFundMe's or any other issues during the probate process. So yeah, this is a purely community service that we are offering. Yeah, we have about 2 more minutes before we wrap up. Any more questions, please? A lot of great questions. Please ask few more questions. We have 2 more minutes. So we take sessions for kids, and for masjids, other organizations, basically to empower you to take these simple steps to protect your family. Okay, any more questions? Shall we wind up then, or? Okay, once again, I just want to thank the board members at Masjid An-Noor for taking this opportunity to have this very important discussion. And this discussion is only as useful as much as action is taken on it. So I humbly request all of you to take the necessary action. It's a very simple process. I hope I explained it in very simple terms. It's very simple, so please have your will and trust done. And once again, Jazakallah khair to the board of Masjid Noor for inviting me and conducting this very important session. I hope it will be useful and protect your family and provide safety to all of your family. With that, I'll conclude. Jazakallah khair and assalamu alaikum wa rahmatullahi wa barakatuh.